Thank you, everybody, for being here today. I am Michelle Morris with Consolidated Planning Group. We've got another great webinar for you. I don't know if this is the first time you've joined us for a webinar or the 101st, but welcome either way. Hopefully, you're going to get some great information today about estate planning and beneficiary designations. We are thrilled to have attorney Elisa Rainey with us. And she's got some great information. So thank you, Elisa, for being here today.
Thank you.
A couple of things. Yeah, just before we get started, I just want to say, first of all, because we're in webinar mode, we can't see or hear the participants, but I know you're out there. If you have any questions or comments, we love those. And you can just put them in the chat box. That's the easiest way for me to keep an eye on incoming questions and let the speaker know if we've got questions. And I think what we'll do is, if you have a question about something that she's currently talking about, I'll let her know. But if it's just kind of a random question, we'll save those towards the end. But we'll get to as many of your questions today as we possibly can. The other thing I want to let you know is that we record all of our webinars and we put them on our YouTube channel. So once you're finished watching the live version today, you can go to YouTube and look at the recording there. You're also going to receive an email that has a link to the recording and the slides. So you'll be able to review this all later on today. So again, I'm Michelle Morris. I'm with Consolidated Planning Group. We are a holistic financial planning firm that focuses on serving the special needs community and planning for special needs. So what that means is, we help families with every aspect of financial planning, just like any traditional financial advisor would. We can help you think about managing your risk, life insurance, various kinds of insurance, your legal needs, planning for the future, saving for retirement or houses or weddings or school for your kids and for your own retirement, and then thinking about how you're going to leave your assets at your death. Every financial advisor should be able to do those things. But we do them through the lens of understanding that the families that we serve have a loved one who might not be able to be completely independent and live on their own. They might not be able to hold a full-time job that's going to support them. So they're going to need that help from their parents for the rest of their lives. So we understand the nuances of benefits from the government and how you get those benefits and what the criteria are. We understand the nuances of planning for the future for somebody who can't earn their own money and needs help from mom and dad. We understand how you leave those things to your family members without jeopardizing the benefits that they can get. And we plan when we are planning for our clients, not to the end of our client's life, but to the end of the next generation's life to make sure that your loved one is going to be supported. We do life insurance, investments, full service planning. We're located just outside of Houston in Sugar Land, Texas, but we serve families all across the country because we mainly work online. I received a note earlier today of somebody who says, "Oh, I just wondered if you have a branch closer to us because I don't have time to drive over to Sugar Land." Well, the good news is you don't have to. And the reason that we meet mainly virtually is because the clients that we serve, they have immunocompromised children and we don't want to share germs, or they need care for their children when they come visit us, or they have to, it's a big production. So we figure it's way easier to skip the childcare worries, skip the COVID worries, and just meet virtually. We are members of the Special Needs Planning Academy. We are nationally certified as Social Security advisors and chartered special needs consultants. So families come to us for lifetime care planning, protection plans, transition planning, of course, ABLE accounts, and all of those little things that you need to think about, and vehicles where your child can have money saved up. And we're here to advocate for you and to educate you. Out of the entire United States, there are over 263,000 financial advisors, but fewer than 200. That's less than a tenth of a percent of those financial advisors actually do special needs planning the way that we do. So you're in the right place. We want you to plan ahead. Get started planning for the future as soon as possible. That gives you a longer runway when your child is finished with high school and, whether or not they go to an 18 plus program once they're finished with that, there's a lot that needs to be done. Are they going to go to a transition program, an educational program? Are they going to go out into the workforce? What is next for your loved one? You have to plan ahead for those things. And the last thing I have to say before I turn this all over is, just be very careful when you think that a sibling is going to be able or willing to step in and become a caregiver. It's easy. It seems like the best plan because, it's not that disruptive for your special needs loved one, but it could be very disruptive for that sibling caregiver. So think long and hard about whether or not that is really the best decision for your family. It could create friction on both sides of that relationship. So we always advise people to be careful about that and just really take the time to plan. It will help you sleep better at night to have that knowledge and peace of mind. So, without any further ado, I'm going to hand things over to attorney Elisa Rainey, and she's going to be talking about beneficiary provisions for our people. So, please, thank you so much again for being here, Elisa.
Well, thank you so much. It's a pleasure to join all of you today. And much of what I'm going to talk about touches directly on those things that Michelle just talked about and the things that Consolidated Planning Group knows so much about in terms of not leaving assets directly to those loved ones with special needs. But often, even though you're having that conversation with your professional advisors, we sometimes forget that other family members whose planning may touch your child or whose planning may touch the individuals for whom you're doing your own planning, that their plans may not be quite so cohesively organized as yours, to make sure that we're best serving the needs of those with special needs. So we're going to talk today about some basic points to keep in mind when making beneficiary designations. And my hope is that you can take this information and share it with loved ones, whether it's the individual's grandparents, aunts, uncles, whoever, so that they too can be informed and share that information, or at least keep it in mind as they're visiting with their own advisors. So let's talk again about what we're trying to accomplish here. So when we're doing planning for our children, whether those children have special needs or not, our goal is to arrange for wise management and investment of those assets going forward. Now, some individuals are able to handle that for themselves. Others need that to go into a trust arrangement so that a professional or a more experienced individual can do that for them. We're also trying to arrange for distributions of income and principal for the benefit of that beneficiary in a way that best serves the needs of the individual. And finally, again, when we have beneficiaries with special needs who may be on means tested government benefits, we need to make sure that the distributions are made in a way and the assets are held in a way that their qualification for benefits is not disrupted. So when we talk about beneficiaries with special needs, we have kind of the old school default strategy was to either leave them out, disqualify them, disinherit them rather. So just ignore that they're there and leave assets to other family members, counting on those other family members to take care of the one with special needs, or just as often, ignore that the individual has special needs, whether that was intentional or just by lack of knowledge that we could do better, and just leave assets outright to that individual in a way that interfered with their qualification for benefits. Now, again, when we're talking about government benefits, which programs are we most focused on preserving? We're most focused on Medicaid. We're very focused on SSI, Supplemental Security Income, and very focused on mental health benefits here in the state of Texas through the Department of State Health Services and DADS, Department of Aging and Disability Services. And all states have some version of those programs, but those are the real means-tested benefits that we can preserve through special needs planning that we're going to talk about later. Now,
We
housing
often we
services. Yes, go
we
ahead.
often refer to those as the waiver programs here in
Yes.
Texas, right?
So the Medicaid waiver programs are the ones that really provide that beefy benefit that where individuals can receive Medicaid services in the community outside a nursing home, as well as those who may eventually need care within a skilled nursing facility.
Right.
Uh, so those are your big means-tested government benefits. We have others, namely SNAP for nutritional benefits and housing. We've had some developments in law regarding both of, well, especially housing in the last year or so, but supplemental needs trusts, which we'll talk about a lot today, are not so much focused on housing. We primarily use special needs trusts to preserve SSI and Medicaid. Now, what I don't reference here is SSDI, Social Security Disability Insurance. That is not a means tested benefit. But even if your loved one is on SSDI and their inheritance won't disrupt their SSDI qualification, they may be in a particularly vulnerable situation such that we think they may at some point in the future need Medicaid benefits. So we want to set them up in advance so that they qualify. But again, looking at those old school approaches of ignore it and let them sort it out later or disinherit them altogether, we just have the ability to do so much better for them and for those who are supporting them. So when we're looking at your assets or the assets of other family members who may want to benefit your child who has special needs, we kind of divvy that up in two big categories. We have non-probate assets and then probate assets. Non-probate assets are those that are controlled by some kind of contractual arrangement. Think beneficiary designation, joint tenancy with rights of survivorship, payable on death or transfer on death beneficiary designations, trust arrangements. So those are all kind of contractual arrangements that dictate where a particular asset goes upon the owner's passing. Probate assets are those that are controlled by your will. So in your will, when you say, I leave everything to my spouse and then I leave everything to my kids, those are your probate assets only. If in reality, on all your investments and your bank accounts and your real estate, you have other beneficiary designations, your will may not really control much of anything, if at all. And often a big part of what we do with estate planning when we're trying to make arrangements for loved ones, for kids, especially those with special needs, we often use trust planning. So at the end of the day, we may realize that an individual has no probate assets because everything is dictated by the terms of a trust. So we went through this already. Examples of common non-probate assets would be bank accounts, investment accounts, life insurance policies, all of which would have beneficiary designations typically. Now, let's say I name my spouse as beneficiary, but then when I pass, my spouse has predeceased me. Well, then that's not going to have a live beneficiary designation, so that asset may still get controlled by my will. All right, revocable trust planning we touched on just a bit, but let me kind of dissect this terminology so that you understand what we're talking about here. Revocable trust means it's revocable as opposed to irrevocable. When I create it, I can still over time amend it. I can put assets in my trust and pull assets out. I'm still the owner as long as I'm living, but at the time of my and perhaps my spouse's death, it becomes irrevocable at that point. We often refer to a revocable living trust as an inter vivos trust. That's a Latin term meaning during a lifetime. So it's created during my lifetime. It's funded in some small measure, usually during my lifetime. But really, the intent in some cases is that it's fully funded at death. whether it's by beneficiary designations or maybe some assets are already in that trust. But the goal is that going forward from that point, it makes things as easy as possible for my family, hopefully avoiding a need for probate. Now we hear all kinds of information about probate, about the complexity, about the burden, about the cost, and those vary, the complexity, burden, and cost vary widely by states. Historically here in Texas, we have a pretty easy probate process. Independent executors can be appointed who act largely free of court supervision. But still, there is cost, there is effort, and we can often minimize that by wise use of a revocable trust with revocable trust planning. All right. I want to speak very briefly, and those the folks at Consolidated Planning Group can speak much more to this. And I'm sure it's been a thorn in their saddle for for a couple of years.
Yeah.
But in January of 2020, you may remember we were all distracted a little bit by COVID at the moment, but the Secure Act rolled out on January 2020 and then has since been amended. And those amendments have spanned from 2022 to 2024. Perhaps even 2025 has seen some refinement of that. But the Secure Act and Secure 2.0 have very much changed the distribution of inherited retirement accounts. So what we would call qualified accounts, IRAs, 401ks, 403bs. In the past, a person who inherited it could still take distributions over their lifetime. Spouses got the best treatment. Kids still got pretty sweet treatment. That changed very, very much as a result of Secure Act. At this point, most people, well, a spouse can still stretch it over their lifetime. Most kids have to take full distribution within 10 years rather than being able to stretch it over their lifetime. But individuals who are disabled or chronically ill still get that lifetime stretch. But we have to be very intentional about how trusts are created so that we don't accidentally disqualify that individual from that lifetime stretch. So just be aware when you're doing your planning, visit with your attorney about that concern to make sure that nothing you're doing is going to disrupt that beneficiary's qualification for that lifetime stretch. And likewise, your financial advisor will give you some guidance on those points. All right, let's talk about supplemental needs trust, because really this is, in my view, the key to making sure that things are done well, so that when you are leaving assets to a child with special needs and other loved ones want to piggyback on a trust that you create for your child, we can do that in a way that preserves the assets in the sense that they can be responsibly managed, responsibly distributed for the benefit of the child, all while not disrupting their benefits, because assets in the trust don't count as the child's assets with a properly drafted supplemental needs trust. And distributions from the trust for the benefit of the beneficiary may not have any impact whatsoever on the child's qualification for benefits, or if it does, it will be a lesser impact than if they had inherited these assets outright. So let's talk about supplemental needs trust in general terms. A supplemental needs trust is also called a special needs trust, often abbreviated S&T. Some folks call them SNITs. I don't like that term. It's a little close to snot, but supplemental needs trust and special needs trust, those terms can be used interchangeably, and even I, in the course of a single conversation, will flip-flop between the two. So as you're doing your own online research, which we all do, don't get sidelined by the different terminology there. And again, in general terms, the purpose of an S&T is to create a trust for an individual who has special needs. Maybe they're on benefits right now. Maybe they expect to be on benefits in the future. But the intent is to allow the beneficiary to get the benefit of the assets in the trust without disqualifying them from programs, government benefits that look at their assets and income in determining whether they're qualified. Means tested government benefits. Again, generally you'll see terminology that is very common no matter the state you're in. So you'll see references to the intent of the trust being to supplement and not supplant government benefits. That's a very common phrase. It is not essential. So if you think, well, I have a supplemental needs trust, but I'm not seeing this phrase, don't fear, don't despair. It's not essential. It's just a common way for attorneys to try to signal to the world this is intended as a supplemental needs trust, not as what we often call a support trust. In Texas, we can be very flexible. We can use a fully discretionary trust, which basically gives the trustee full discretion when to make distributions, how to make distributions, even whether to make distributions at all, which is a little scary as the parent wanting to make sure their kids are taken care of. But it's a fully discretionary standard which lets the trustee flex and flow and adjust to government benefits as they look now and in the future, and the needs of the beneficiary as they are now and as they may be in the future. So right now I may have a child who needs support from me. They need guidance. I'm providing bumpers, but maybe they're working. Maybe they're not on SSI right now. But due to some situation, I may fear that they're particularly vulnerable or very likely to need government benefits down the road. And I can set my trust up so that the trustee can distribute very generously, pay all their rent, all their groceries, even give them cash right now. But then later, if they need to qualify for benefits, then the trustee can draw back and no longer make cash distributions, restrict how they pay for rent. I mean, they can again adjust as the needs of the beneficiary dictate over time. The beneficiary with special needs can never, ever be their own trustee, and they can't have control over the trustee. So they can't have the ability to remove and replace a trustee. They can't kick them out and become their own trustee, because the overarching rule is if the beneficiary has control over the assets in the trust, and they effectively would if they could fire and hire their own trustees, then they are considered to own those assets that are in the trust, and all of those assets are considered theirs. So they can't have control over the trustee in a way that would be deemed to have control over the assets in the trust. Be aware, and I'm kind of overly simplifying here, but I want you to generally be aware, distributions of cash from a special needs trust to an individual on means tested government benefits are generally considered income. And many of these programs have income limits. So if I give $1,000 out of a trust to a beneficiary, if that kicks them over the income limit, they may lose their benefits for that. So rarely do we see cash distributions coming out of an SNT for a beneficiary. Are there exceptions? Yes, but that's a general cautionary rule that we follow. Also, distributions for shelter can reduce certain benefits. Not all. Some Medicaid programs, especially these waiver programs that Michelle and I talked about earlier, those are not affected by distributions for housing, but SSI very much is. And a general rule, this could be its own session, and probably has been, but a general rule is that distributions for housing or shelter, that includes not only rent, but also homeowners insurance, taxes, utilities, all of those count as housing and will reduce SSI benefits by up to 1/3. Now, is that terrible? No. Frankly, it's pretty generous by Social Security Administration. So if my SSI benefit, and I'm rounding numbers here, but if it were 900 and they reduce it by 1/3, then now I'm getting 600. But that'd be far better than totally offsetting my benefit by these housing expenses paid from the trust. My trust could be paying $10,000 a month worth of housing for a really nice house, but it could be paying $10,000 a month and I just get a $300 deduction in my benefit. So still very much worthwhile. So what would we use a special needs trust for? Well, we can pretty much use it for anything, but again, we don't want to distribute cash. Be aware that distributions of housing can impact some benefits, but luxuries, and when I say luxuries, most of what I have around me right now would be considered a luxury. So iPhones, iPads, nicer furniture, anything, any kind of technology often is used, but it can be luxury clothes and handbags. Education or training, rehab, care expenses, vacations, camps, funding of an ABLE account is another one. And we'll have time, I hope, to visit about ABLE accounts at the end of our talk today. If I don't get there, because I'm notoriously bad about talking too long, but there is more information about ABLE accounts in your materials. But at this point, we can put up to 19,000 per year into an ABLE account. That stays the same for 2026. I bet
That is going
2027
up to 20,000 for
for 20.
2026.
Oh,
We've
thank
just
you.
learned, yes, we've just learned, originally they did say it was going to stay the same, but they revised that issuance and they said that, yes, we are going to be able to put 20,000 into the ABLE account next year.
I'm so glad. That's good news. And thank you for this is a shared learning experience. So thank you for
Yes.
that. When we talk about SNTs, kind of the universe of special needs trust, there are two distinct types, and you need to understand this difference because it will help you cipher through some of what you're seeing online. And it's very important when you're looking at your estate planning and suggesting to other family members how they might do theirs. So there are third party SNTs and there are first party SNTs. First party S&Ts are often called self-settled S&Ts. The big difference is where the money is coming from. The assets funding the trust, are they coming from mom and dad or grandma and grandpa, and they're coming straight into the trust? That's a third party S&T. Did the beneficiary himself or herself have assets before they got on benefits? Or did they receive a recovery from a personal injury action? Or more akin to what we're talking about today, did a loving family member leave assets outright to them, not knowing that those assets would disqualify the beneficiary from benefits? And now we're having to regroup. This goes back to that old school thing of just leave it to them and let them sort it out. A first party trust is what we have to use sometimes to sort it out. But looking at your planning and in making recommendations to loved ones about how they might plan for your child with special needs, a special needs trust should absolutely 100%, I'm going to say without exception, although we always know there's some exception, but without exception, you need a special needs trust for that child. It can be tucked into your will. It can be tucked into a larger revocable living trust that you've done for your overall estate planning, or it can be its own standalone trust, which is my favorite. I recommend this approach, just a standalone inter vivos third party special needs trust. Again, it doesn't have to be funded by very much right now, but you already have it there. You can even float it out to SSI and to Medicaid for them to have a chance to critique it if they don't like the way it looks. But the goal there is when you pass, it can be named as beneficiary on life insurance policies, investments, can be named as a beneficiary in your will or your revocable living trust. So really the funding all comes together in that third party S&T upon your passing. Likewise, if you've done an S&T for your own child and you're having this conversation with other family members about, I know you've mentioned leaving something to our child upon your passing. We have set up this trust, and if you could name this trust instead of our child, that would be so helpful to us and to him or her. So other family members can leave assets to a trust established by you. Now, you would need to talk to your attorney about whether that trust would need to be irrevocable from the get-go, or if it just becomes irrevocable at your passing. Also, other family members leaving assets to a trust set by you or established by you would also need to be aware of who you have named as backup beneficiaries. So I'll use my own family as an example. I have two boys, and let's say that one of them has special needs and I've set up a trust for him. Then typically I would have his brother named as a backup beneficiary behind the one for whom it was first established. But, and I've had families who wanted to use that same trust, but then realized, oh, we don't all have the same vision for who the next beneficiary is. So if y'all don't share that vision, they may need to set up their own trust. So it just depends on family circumstances. I've had some very cooperative former spouses want to piggyback on the same trust, but then realize they didn't see eye to eye on successor beneficiaries. So that can be complex. So again, in general terms, types of trusts, third-party S&T is one that you establish as part of your estate planning. You can utilize it instead of naming your child directly as a beneficiary. Other families can piggyback on that same trust. The other type of S&T is a first-party trust. And if at some point your child comes into their own money and they're under age 65, that's a critical part of it here in Texas, under 65, then they can set up, or someone on their behalf can set up a first party S&T and put assets into it. Now, the big difference, and I'm not sure if it's on this slide or, yeah, let's talk about this. So third party S&T, we've talked about this, uses third party funds. Here's a big difference between the two. A first-party trust must include a Medicaid payback provision. A third-party trust does not. Let me explain what that means. With a first-party trust, again, that's one that received the beneficiary's own money. Maybe it was inheritance that came to them directly, a personal injury recovery, whatever it may be. When that beneficiary passes away, the first beneficiary behind them in a first-party trust must be the state or states that have provided Medicaid benefits for that individual over their lifetime. Now, if there's not enough money remaining in that trust to satisfy all the states, they each get their pro rata share. But I want you to be mindful that what I say, Medicaid is who gets paid back, not SSI, not SSDI. So Social Security Administration doesn't get paid back out of these trusts. It's only Medicaid. Now, a third-party trust, which we see here on the slide as we have it here, the one that you would create as part of your estate planning, does not have a Medicaid payback provision in it. So when that first beneficiary passes, you get to decide who that next beneficiary is. And often it's the beneficiary's siblings or other family members who you want to benefit in that way. When in setting up,
Can I ask one really quick question? I'm so sorry to interrupt.
no, go
Do
ahead.
you name, when you're making the special needs trust, is that when you put in the beneficiaries and the successors? Or do you put the successors into your will, or both?
The way our firm does it, in the S&T itself, in that trust, you designate the first beneficiary, the one with special needs, and we go ahead and name several layers of backup beneficiaries behind them. We also name several layers of trustees, and the trustees are the ones in charge of managing it, investing the money, making the distributions. Those are the trustees. So we have alternates already built into that trust document. Sometimes
Perfect.
if all of our alternates fail, a court can name a successor trustee. But we also have gotten to where we usually give the trustee the ability to name their own successor in case they're the end of the line, and so that we don't have to go to a court for that. Now, when we do a standalone third-party S&T, which is how I recommend you do it, the individual creating it also still has their own will as a backup measure. And within that will, we still tuck in a backup S&T within that will so that if something has happened to this standalone trust, if it evaporated into thin air by the time the person passed away, we have a backup measure built into that will. So it feels redundant as clients are reading it, and you may have had that experience with your own documents. But just know that we attorneys like to have some redundancy built in with the creation of these trusts in case something is somehow leaking through to the beneficiary. Great question.
Thank you. Thank
All
you to
right.
Diane who asked.
Oh, very good. Now, first party trusts again, created with the beneficiary's own funds, they can be created by the beneficiary himself or herself if they have capacity to do that. It can also be created for them by a parent if a parent's living, a grandparent if they're living, a guardian who's been appointed by a court, or a court directly, even if there's no guardianship already pending in that court. So again, first party trust can be created by a parent, a grandparent, a guardian, the court, or the beneficiary himself or herself, provided they have the capacity to do that. Those trusts need to be created prior to age 65. It has to be irrevocable from the get-go, meaning there can be no provision in the trust that allows for future amendment of the trust. Now, here in Texas, our courts automatically have the ability through a judicial action to amend a trust, but we can't acknowledge it in the document. If we admit it in that document, then Social Security says, well, it's not irrevocable. So we just have to stay silent and recognize that most states' laws allow their courts to amend a trust if necessary under certain circumstances. And again, these first party trusts have to include a payback provision. Now, I referenced a couple of times that age 65 cutoff for first party trusts. The trust has to be created and funded prior to the beneficiary's 65th birthday. But the trust can continue to live on and support the beneficiary and make distributions to the beneficiary even past their 65th birthday, of course. It's just that we can't add more money to it. Now, be aware that kind of a nuance of special needs trust is these master pooled trust. So master pooled trusts are a type of special needs trust. Some states allow a master pooled trust to be funded or created after the beneficiary's 65th birthday. In Texas, we cannot do that. Hopefully that change will come in the future. But if you're in a state other than Texas and you've heard about master pooled trusts being created after 65, that may be true for you. Doesn't mean you need to go talk to an attorney in your state about it, but it is true for some states. Able account.
Elisa, before you go on to able accounts, could you speak a little bit about child support and the what we do with that?
In terms of whether SNTs can be used to pay for child support?
No, the fact that if a child is receiving child support after age 18, because, here in Texas, you can do that. You can have child support go beyond age 18 if there's an individual with a disability. That child support needs to be redirected to this first party special needs trust. Otherwise, it counts as income to the child or the 18-year-old adult, and they would lose out on some of their SSI and Medicaid benefits.
That is correct. So in Texas, Texas law, as most states, permit a court to order ongoing child support for a child with disabilities beyond that 18th birthday or graduation from high school. So we can have and usually do see ongoing child support for the non-custodial parent. And in those cases, we need a first party trust, even if there's not some big lump sum of money out there that's coming in, but it's just going to be a monthly support obligation from that parent. We need that support to come into a first party trust. In Texas, the court has to expressly order that the child support is paid to a first party trust. So that's a mandatory requirement here. And again, the first party trust can be created by a parent, grandparent, or the court. My experience is when we're using child support to fund a first party trust, I see courts wanting to create the first party trust rather than having mom go to her attorney to create one and then the trust ordering child support to that. Because again, if mom's creating it, we might not have the beneficiary designations line up with what both parents would want. So yes, I expect in most of those cases, the court would create the trust and the court must order child support to be paid directly to that trust. And that keeps it from counting as income to the child.
Mhm.
And then likewise, if those assets are accumulating over time and then maybe getting spent in big lumps, but accumulating in between, the balance of that trust does not count as the child's asset in determining qualification for benefits.
All right, thank you. And then, so trustees manage the trusts. And then if there's money left in the special needs trust, if it's a first party, it could go back to repay Medicaid. And if it's a third party, you would have beneficiary designations on it for whoever is left over, or a
That is,
charity or something like that, correct?
that is correct.
Perfect. Thank you.
Absolutely. All right, I am tickled that we have a few minutes to visit about ABLE accounts because I think they are the bee's knees and just really one of the greatest tools that have come along in decades for the special needs community. So many of you may already be using ABLE accounts, and if so, kudos and hats off to you. Others may have heard about them, but not really understand them. So let's kind of try to shed some light on them today.
And let
So
me say, as she's going over the ABLE account, you might think, who can set this up for me? We can at Consolidated Planning Group.
there you go. Thank you, Michelle. So ABLE stands for Achieving a Better Life Experience. And basically, if you're familiar with 529 accounts, ABLE accounts are set up on that same legislative chassis. So there are some similarities between the two. But in general terms, a you can establish an ABLE account, only one. Each beneficiary can only have one ABLE account, but they are sponsored through states. Texas has an ABLE account. Ohio was one of the first through the gate, so we see a lot of Ohio ABLE accounts. Their program in particular is branded as the stable account, STABLE. For a long time, we used the stable account for all of our clients, even in Texas, just because, again, they were the first through the gate and had a lot of features that Texas did not yet have. More recently, I've been very comfortable with the Texas ABLE account, and we've been using those for our clients. In general terms, in order to use an ABLE account, a beneficiary must have been disabled prior to age 26, except that's going to age 46 next year. So anyone disabled prior to age 46 as of January 1 will qualify, provided they are disabled within the definitions set forth by Social Security Administration. Now, certainly if someone's already on SSI or SSDI, we know that they're qualified, but they don't necessarily have to have been approved for Social Security benefits. We know there are many families out there who, for whatever reason, and there are many, just never applied for Social Security, just didn't think of it as a key part of their child's support. And so even if someone's never applied for benefits, they can qualify. Now, here in Texas and Ohio, we don't really have to document disability in order to establish the account. It's more, there's a question, if called upon to document your disability, could you do it? Yes. So you need to make sure that you have sufficient medical evidence, maybe even school records, other documentation, so that you could present it to validate and prove disability, but you don't necessarily have to submit that along with the application. In my experience, these application processes for ABLE accounts are completely online. So I've had clients with good success setting up their own ABLE accounts. Others need more support and guidance, especially if you're busy caring for a loved one. It's nice to delegate that to folks like Consolidated Planning Group who have experience doing it efficiently and correctly. Again, each beneficiary is limited to one account. The purpose of an ABLE account is money in it. It's much like a first party S&T. So assets that are in the ABLE account don't count as assets of the beneficiary. They don't interfere with qualification for benefits, but ABLE accounts are even more flexible than special needs trusts in terms of distributions and not having those distributions interfere with qualification for benefits. So for example, we talked earlier about a parent or a trust making distributions for the beneficiary's housing and how that can result in a 1/3 reduction in SSI. If that same parent or trust instead puts money into an ABLE account And then the ABLE account is used to pay those housing expenses. There's no 1/3 reduction. It is gold. Another great use of an ABLE account is we often have individuals with special needs. They need to maintain qualification for benefits, but they're not incapacitated. They would love to have money at hand where they can go out to eat, they can pay for concert tickets or even just a movie ticket. They want to have access to some of their own money. And with an ABLE account, they can have access to that account through some type of debit card or transfer of funds from the ABLE account to their own checking account where they can use it. Now, once it comes out of the ABLE account, if it's just sitting in their checking account not being spent, then if we roll around to 12:01 a.m. the first day of the next month, then it counts as an asset to them. So generally, we would want those ABLE account monies to stay in the ABLE account and only be pulled out in real time as we need to use them for another expense. And again, we can have the money paid directly for expenses or come out to the beneficiary's account and be used to pay expenses from there. Again, right now, 19,000 for 2025 is the cap, 20,000 for 2026. If the assets in that ABLE account accumulate and ever crest $100,000, then SSI benefits go on hold until that balance comes back down below 100,000. In my view, I don't see ABLE accounts being used in that way. I prefer that ABLE accounts be used as the sidecar to your special needs trust motorcycle. And it's a great accessory, but the bulk of the money is in the special needs trust. It's being managed and invested and much more strategically used and held. But then as we can push money out, whether it's just to pay housing expenses or again, give that beneficiary some liquidity, then we can just siphon money out of the trust into that ABLE account. And so my recommendation to clients and families is not to let that ABLE account accumulate. Now, I compare the ABLE account to a first-party trust, and a big reason I did that is just as a first-party trust has that Medicaid payback requirement, so too does the ABLE account. The ABLE account requires, by its statutory mandate, that the state or states that have paid Medicaid benefits for that beneficiary get reimbursed with assets remaining in the trust after the beneficiary's passing. Now, it's a little more flexible than a first-party trust. Technically, an ABLE account could be used to pay funeral expenses before reimbursing the state, whereas a first-party trust cannot. Also, ABLE accounts, Medicaid is only reimbursed for expenditures made by Medicaid from the date that the ABLE account was established ongoing, whereas a first-party trust, you're opening up that trust to reimbursement to Medicaid for benefits paid throughout the beneficiary's lifetime. So ABLE account is a little more is a little more strategic in some regards, but again, it doesn't meet all of our needs because it can only receive a limited amount of money per year, whereas a first-party trust could receive much more. Ideally, everything's going into a third-party trust, and we don't have to worry about those state payback provisions in any regard. All right, let me see what we have here. I think we've gone through all of this.
We say about the able and first party and third party accounts is think of the able as your savings account. Like I have checking and savings at Chase Bank. When I need more from my savings account, I move it over to checking. When I have too much in checking, I push it to my savings. That short-term savings, that's your able account. Your long-term retirement 401k savings, that's the third party special needs trust. And the first party trust is in between, but you want to spend it first because if it's still in there when the recipient passes, it goes back to Medicaid. So spend the able, spend the first party, leave the third party for long term, and then you can set up a beneficiary on that so that it flows back into your family when it's not being used anymore.
That's an excellent explanation. The checking versus savings analogy, that's a great way to describe it. So I do want to make one little last point about ABLE accounts. When you read literature about ABLE accounts, it says that distributions have to be made for qualified disability expenses. The definition of a qualified disability expense is extremely broad. In general terms, I tell folks that if it's an expense for a person with a disability, it's probably a qualified disability expense. If somehow a beneficiary finds something that doesn't qualify as that, then the impact is they simply get taxed on a portion of that distribution, which for most of our beneficiaries, they're not paying a tax anyway. And so it's just a tax, it's a penalty on top of their tax. And if they're paying zero tax, well, anything times zero is still going to be zero. So ultimately it's not really a downside, but be aware that you'll see that terminology in literature about ABLE accounts. So I think that does it for me today. We've talked about all of these things, so I'm kind of going through these last few slides. And Michelle, I know that you have a little bit more information for us.
I do. So, Elisa, if you would put your contact info in the chat box while I go through the rest of these. And if anybody else has any questions left over that maybe I didn't see it or we didn't get to it yet, please let us know. We want to get those questions answered for you. That's why we're here today. One question I saw that was not answered: annuities. If you inherit an annuity, what is the stretch on that for the children? Do you know?
Say that again. I was looking
So
for,
you were talking about 5 years. If you inherit an IRA, you have 10 years, sorry, to spend it. What about if they inherit an annuity? Do you know what the time to spend that would be?
it would depend entirely on whether it's an IRA annuity. So if it's a
Mhm.
traditional IRA annuity, that time period is just the same as a traditional IRA invested in any other asset. So the fact that it's an annuity does not change that distribution period for for
Okay.
for tax purposes. Now, there may be built-in terms in the annuity contract itself that dictate how those distributions are to be made upon the passing of the annuitant, but from a tax perspective, there'd be no difference.
Perfect. So, the things that we've talked about today, before this webinar started, Elisa asked me, how many webinars you do, like one a month or every other week or what? The truth is that we do 2 or 3 webinars every single week to really share our knowledge with the community and try to help as many families as possible. This keeps us going because from these webinars, we are able to help you. You schedule appointments with us, and we're able to build our business from this. So don't be surprised when you see advertising from us, letting you know what webinars we have coming up. And we do webinars on all of these topics: ABLE accounts, government benefits, residential living communities, what happens after high school, all of that kind of stuff. If you want to see what we have coming up on our schedule, you can click this link and it will take you to our website. We have an events tab there where you can look at all the upcoming webinars and register for whatever you might like to see. And then when you do register for the webinar, after it has presented, whether you're there or not, you will receive an email with the link to the recording and you will receive the slides. So not only that, but it reminds you when the webinar is coming. This is our entire team at Consolidated Planning Group. We are small, and I love that because it helps us to get to know all of our clients. And all 4 financial advisors work together as a collaborative team on every single client. So you get Allison and Jeff, who are a married couple. They've got 4 kids all together, and 3 of them have disabilities. And you also get Michelle and Andy. We are a married couple. We've got 2 boys, and one of them has disabilities. So we come from the perspective of parents and experts in this area. Again, members of the Special Needs Planning Academy, chartered special needs consultants, and Social Security advisors. So We at Consolidated Planning Group offer a completely free initial consultation. Any questions that you might want to ask us, you can speak with one of the advisors. It would be myself or Allison or Andy. You can speak with us, get your questions answered. We will give you some advice based on a short questionnaire that we have you fill out. And then we'll talk to you a little bit about exactly how our program works and what we charge, and if it would be a good idea for you to move forward with us. It's very low pressure, I promise, but we are going to be reaching out to each and every one of you to try to get you to schedule this free consultation. If you'd rather we don't call, you can call us first. You can email the office. You can use the QR code, or you can call or email me directly. My information is in the chat box, and I'd be happy to set up that consultation for you. And this slide also includes the link to our YouTube channel, our Instagram. We have a podcast in case you would prefer to listen to these instead of watching them. And we also have a Facebook page. So follow those for more information going forward. Reach out to us for your free consultation. And feel free too to reach out to Elisa for any questions that you have on the legal side. We always say that, we're the money side of things. And Elisa at Rainey and Rainey, she's the paperwork side of things. She can draft documents, we cannot. She can give legal advice, we cannot. You need both sides of that coin to have everything set up correctly for your loved one. Thank you again, Elisa, so much for being here with us today, and all of the participants out there with us. I'm sure you've picked up some great information today, but like I said, if you've got any follow-up questions, please reach out. I hope you all have a fantastic day, and that we get to hear from you soon. Goodbye, Elisa. Thank you. Goodbye, everybody. Thank you, Jennifer. Bye-bye.